brought into the ninth schedule by that AMCDMCent or any provision in any of them, abrogata, have the basic clements or essential features of the Constitution, will have to be examined when the validity of those acts is gone into. Further, the contention that Article 31B is intimately connected with Article 31A is unacceptable and must be rejected. 5.4, 5.6, Palikar, the Constitution, 24th, 25th, and 29th Amendment Acts are valid. 632J. The power and procedure for amendment of this institution were contained in the unamended Article 368. The procedure which bring about the result of amendment of the Constitution is the exercise of constituent power, PPL. From 15566-632. The Constitution is not an indigenous product. When our Constitution was framed in 1949, the framers of the Constitution knew that there were two coil-trast-CD types of democratic constitutions in vogue in the world. One, the one-bezable type, which could be amended by the ordinary procedure governing the making of a law, and the other, the rigid type, which could be so amended but required a special procedure for its amendment. From the special provision made in Article 368 for the amendment of the Constitution, it follows that our Constitution is a rigid or controlled Constitution, because the Constituent Assembly has left a special direction as to how the Constitution is to be amended. In view of Article 368, when the special procedure is successfully followed, the proposed amendment automatically becomes a part of the Constitution, or, in other words, it writes itself into the Constitution. The Constitution of India gives specific powers of ordinary legislation to the Parliament and the state legislatures, in respect of well-demarcated subjects. Since the result of following the special procedure under Article 368 is the amendment of the Constitution, the process which brings about the result is known as the exercise of constituent power by the bodies associated in task of amending the Constitution. Therefore, when the Parliament and the state legislatures function in accordance with Article 368 with a view to amend the Constitution, they exercise constituent power as distinct from their ordinary legislative power under Articles 245 to 248. Article 3.8 is not entirely procedural. The clear mandate that on the procedure being followed, Kesavananda v. Kelala, Pajakar, J. 4. The proposed amendment shall become part of the Constitution, is the substantive C part of the article. Then 4. The special power to amend the Constitution is to be sought in Article 368 only and not elsewhere. 558 to 563. Automobile Tray 1 Port Ltdv, State of Rajasthan, 1963. 1 SCR 491 and Macaulay v. the King, 1920, AC 691 referred to, are the view of the leading majority in Golai Nath, that the power to amend the Constitution is to be found in Article 248 read with the entry 97 list I held incorrect. pp. 55666. By describing the power as sovereign constituent power, it is not the incantation to declare that legal sovereignty lies in this or that body. The word sovereign is used as a convenient qualitative description of the power to highlight its superiority over other powers conferred under the Constitution. The word therefore simply stands as a description of a power which is superior to every one of the other powers granted to its instrumentalities by the Constitution. The amplitude and effectiveness of the constituent power arc, not impaired because it is exercised by this or that representative body, or by the people in a referendum, and the power to amend does not become more or less in content according to the nature of the body, which makes the amendment. The people sees having withdrawn from the process of amendment and entrusted the task to the Parliament, instead of to any other representative body. It is obvious that the power of the authorities designated by the Constitution for amending the Constitution must be coextensive with the power of a convention or a constituent assembly. Had that course been permitted by the Constitution, the raison d'etre for making provision for the amendment of the Constitution is the need for orderly change. Between the two coordinates RJ, namely, the need for orderly government and the demands for orderly change. Boyle, in accordance with the Constitution, the makers of the Constitution provide for its amendment to the widest possible limit. Whichever way one looks at the amending power in a Constitution, There can be hardly any doubt that the exercise of T liat power must correspond with the amplitude of the power, unless there are express or necessarily implied limitations on the exercise of that power. The meaning of the what amendment of the Constitution cannot be less than 1 amendment by way of addition, variation, or repeal of any provision of the Constitution, which is the clarification of that expression accepted by the Constitution 20.